Hi, Taylor Kaspar here. I help families navigate the probate system when their loved ones have passed away without the right kind of plan in place. And I actually want to talk to you today a little bit about probate and what actually happens in probate. I've been finding out that a lot of people don't know what probate is, don't know what probate means, and don't know how to navigate the system of probate if they ever need to, or that they even need to go through the probate system. That's something that not everybody's aware of. So first and foremost, what is probate? Probate is the court process that takes place after someone has passed away that allows for the personal representative, the family, the friends, whoever it is, to actually transfer that person's assets to a third party individual or to whoever the beneficiaries of those assets and property would be. Okay, so it's a court process that takes place. How it actually works is something that a lot of people don't understand. First and foremost, a lot of people think that if you have a will, you don't go through probate, and that is not true. If you have a will, the only way for that will to take effect is to go through the probate system. If you have real property like a house or something with a title, that has to go through the probate system for there to be authority to pass that item, that house, on to whoever's going to receive it so that they can take ownership of it. Similarly, if you have retirement accounts, investment accounts, bank accounts, things that could pass by beneficiary designation, but there's no beneficiary defined, then those items have to go through the probate process as well so that these companies know that it's okay to actually liquidate these accounts and these assets and pass them on to whoever is the rightful beneficiary, the rightful heir who's going to take ownership of those things. So probate starts by, first of all, getting a whole bunch of documents filled out, signed, and filed with the probate court in whatever county it is that this probate's going to be filed with. Oftentimes, that's the county where the probate or where the real property was located, or that's the county where the person who passed away was living at the time that they passed away. Okay, so tons of documents filled out, completed, and they get filed with the probate court. The probate court then comes back and gives a notice to the filer, whether that's the attorney, whether that's somebody who's asking the court to be the personal representative, which is the person who takes care of all this, who distributes the property and the items. The court then gives notice to whoever filed the case. And they say, okay, we received your documents and we're going to have a hearing for you, and it's going to be at this date at this time. Then what needs to happen next is there needs to be notice given to anybody who has a legal right to receive notice that this probate is going on. So that's going to be any heirs, so a surviving spouse, children of the person who passed away. If there is no spouse and children, that might be siblings of the person who passed away. It might be nieces and nephews. It might be grandchildren. Statute and law gives us a whole list of who has legal right and priority to get the notice that this proceeding is going on, right? So then notice would have to be given. So the petition and the notice of the hearing date and time, all that stuff's going to have to get sent to whoever has the right to receive that stuff. That has to happen before the hearing. Also, the probate court and the law is friendly to creditors. And so once you get the notice of the date and time of the hearing, the notice has to be published in a legal newspaper to make sure that anybody who's a creditor, anybody who might demand money from the estate of the person who passed away, has notice of that as well. So because of all these requirements and the red tape that has to take place before you even get to the hearing that gets scheduled by the probate court, because of all of that, your hearing, as you can imagine, is going to be a little bit into the future from the time that you file the case. So you're not going to file a case and have a hearing next week. You're going to file a case and you might have a hearing 12 weeks or 16 weeks or 20 weeks from the date that you filed that probate case. So it can really get out there because you have to give notice to people who have the legal right. You have to publish notice in a legal newspaper to make sure creditors have the opportunity to come be a part of these proceedings if they want to be. And then you also have to give notice to the Commissioner of Human Services, because the county or some sort of governmental agency might have been paying public benefits to the person who passed away. They might have been paying for medical care for the person who passed away, and they have a right to compensation as well. So, of course, this isn't an exhaustive list of all the people who might come forward, all the creditors that might come forward, and all the people who might need legal notice. You'll have to actually have your case evaluated or have your situation evaluated, take a look at the law, get an actual legal opinion and actual legal advice from somebody who knows your case at the time that this is going on for you. This isn't an exhaustive list, but I'm just saying this to illustrate the fact that there's a lot of time delays in probate because we want to make sure that anybody who might come forward and might stake a claim to this estate has the right to do so. So that makes it take longer than a lot of people realize and expect. And a lot of people don't realize and expect that the law is friendly to creditors, governmental agencies, and people who might want to recoup money that they've spent or money that they've lent during the person who passed away's lifetime. And now, you think you're going to inherit, and maybe that inheritance is reduced by the fact that all this money has to go out to pay final expenses, illness, governmental benefits expended during the person's life, and other credits and debts that the person might have had. Okay, so it's already a process just to get to the hearing. Then you get to the hearing. You might hear that Minnesota is a probate friendly state, and I would say with respect to how the hearings go, it can be, right? The hearings aren't terribly long, but there is a process to the hearings. It is a court hearing, so you need to show up, and you're going to be in front of a referee or a judge who will conduct the hearing and get the information needed to allow for this probate to move forward, right? Now, after the hearing is held, that's finally when things can start being distributed and assets get unfrozen. Because remember, leading all the way up to this, from the time that the person passed away to the time you get before the probate court, the assets are frozen. You are not able to tap into bank accounts that didn't have other signatories or other owners on them. You can't touch assets that didn't have beneficiary designations on them. You can't touch property that wasn't also titled in the name of somebody else. So anything that was owned just by the person when they passed away has been frozen this entire time. So it's not until the hearing is done and we have a personal representative appointed that these assets become unfrozen and are ready for distribution. Now, that's great that they are ready for distribution, but if you have minor children involved in the matter, or you have a lot of fighting that's gone on between potential heirs, you have certain creditor claims, or you have medical assistance claims, well, then the proceeding is going to be what's called formal, meaning that every time you want to distribute property, you might have to go back to court and have another hearing for that distribution. So say you want to liquidate the house, you want to sell the house, or say you want to pass the house to who you would believe is the rightful heir, whatever the law says. Well, if minors are involved, medical assistance is involved, certain types of creditors are involved, that requires an additional hearing. And so that can make it take longer too. There can be time and expense related to that as well. And then depending upon how it all goes, once everything's distributed and the proper notices have been given, then you're finally ready at that point in time to close out the probate and be done with the matter, so that everything can be distributed and life can go on. So that is kind of a high and low summary of what probate even is, how it tends to operate, what happens in probate, and what are some of the things you need to look out for if you're dealing with a probate. Or having heard that, if you don't think that you ever want to deal with a probate, or you wouldn't want your loved ones to deal with a probate. That's just a little more information about it, because it is something I've been finding a lot of people asking me questions about and being confused about. So there it is. Again, Taylor Kaspar here, owner, managing attorney of Legacy Estate Planning in Burnsville. Hope you got something out of this, and you have a wonderful rest of your day.